Good afternoon. My name is Sandra Whiting, and I'm your host for Ask a Professional, the BBPA series where we have important people to help us with many great topics. Today, we have Natasha Smith and Zeineb Yousif, two lawyers, and they're going to be discussing key considerations in starting, naming, and scaling your nonprofit. Welcome, Natasha and Zeineb.
Thank you.
So I wanted to just share a little bit, and before I do that, I want to apologize to our guests who have been logging in. Apparently you had to do a double login. But do you know why that happened? Because today we have two guests. So there's always a reason in the universe for things. But apologies for that, and thank you for taking the time to be with us today. So let me just share a little bit about Natasha Smith. She is a partner in Miller Thompson's Social Impact Group, a practice dedicated to providing practical legal advice to charities and nonprofits. And then we have Zeineb Yousif, and she's a labor and employment lawyer with Miller Thompson. And she also provides practical, proactive advice on a wide range of labor and employment matters. They have a much longer bios, but I'm going to let them tell you about themselves. So over to you, Natasha, because I understand you're going to be sharing a presentation.
Sure, yeah, thank you. So I think before I put the presentation up on the screen, first, thank you, Sandra, for the warm introduction, and good afternoon, everyone. I think that's enough spent on me. I want to get sort of into the meat of the presentation. And I think, you know, when Zeineb and I were sort of thinking about what can we present to your members, I think I'd like to give a little bit of context for why we think this presentation is timely, and the discussion we're about to have. So really, some of this is coming out of sort of the unfortunate and very high profile events of June. You know, many Canadian nonprofits serving the Black community received an influx of donations or really inquiries about how to make donations to their organizations and support their programs. So very, very thin but promising silver lining to some of the events that happened in June. And so some of you on this call are likely involved with organizations that may have received these inquiries and donations. And of course, the concept of receiving inquiries about donations is not distinct to Black community organizations, but it's certainly, when we talk about timeliness, is something that has really kind of come to light or been highlighted this past summer. And then the interesting thing is the large number of organizations that are serving the Black community are really grassroots, and they're run predominantly by volunteers as nonprofit organizations without registered charity status. So out of the events in the summer, in some cases, really regardless of whether the organization was a registered charity or not, organizations received contributions, but in other cases, the fact that they weren't registered charities and could not issue donation receipts really hampered their ability to kind of capitalize on the sudden attention that was being paid to the Black community and Black community programs. And then for the organizations that did receive donations, regardless of whether they were charities or not, they're now in positions to kind of scale up their organization, and they're getting ready to move beyond this grassroots stage, which means that they're looking to restructure their organizations and hire some additional employees. And again, the idea is that perhaps some of you on this call are involved in these types of organizations. So this presentation is designed to kind of canvass the governance, the tax compliance, and the employment law issues that are really relevant to organizations as they're looking to go from maybe unincorporated to incorporated, maybe obtain charitable registration, and then to hire staff. So we have a number of slides. I'm going to start by taking you through the governance and tax compliance overview. So I will now share my screen, hopefully successfully. Okay, what is the best screen? This one. Can everyone, well, I hope everyone can see that. The question is how to take you through the slides. There we go. Okay, so we know who's on the call. So the agenda is really, I will take you through governance and tax compliance considerations, particularly around an NPO. What is an NPO or a nonprofit organization versus a charity? What are the pros? And I call them considerations. I don't like to call them cons necessarily, but considerations of charitable registration. What does the charitable registration application process look like? Once you are a registered charity, what are some of your ongoing tax compliance obligations? And then what are some governance considerations that, that you should think about? And then Zeineb will take it from there, and she'll talk about employment matters, particularly what it means to start the employment relationship and things you need to consider there, some key obligations as an employee, and then what happens if you need to terminate employment. And forgive me if I look to the side, I've got two screens going on my kitchen table here, so I'm just pulling us through. So the first thing I'd like to highlight is the differences between an NPO and a charity. A lot of times when organizations first contact me, they say, you know, I'm a registered NPO or I'm an incorporated charity. And so that leads me to sort of trigger and think, okay, we need to think about what are the differences here. And that's kind of important. So in terms of your tax status, a nonprofit organization, which has a very specific definition under the Income Tax Act, it is tax exempt. A registered charity, which coincidentally does not have a specific definition under the Income Tax Act, is also tax exempt. So they're the same when it comes to their tax status. Their corporate status is oftentimes the same as well. An NPO can be structured as what's called a without share capital corporation, and so can a charity. And what this means is you're incorporated under legislation governing nonprofits, and you are a corporation that does not issue shares to shareholders like we see in the for-profit context. And so that's why you're called a without share capital corporation. An NPO and a charity could also be structured as an unincorporated association. So they are not incorporated, they are not governed by a corporate statute, but they are instead governed by a constitution or a bylaw that the group of members come together and agree upon. You see this most often, particularly in the charity space, for like a church parish or something like that. That's oftentimes where we see an unincorporated association the most. We highly recommend against operating as an unincorporated association. There are a number of problems with this, particularly because around liability, for instance. If you are operating as an unincorporated association, the members actually become subject to the liabilities of the organization. Whereas if you're a corporation, then the liabilities of the corporation are contained within the corporation. So the members are not ever liable, and the directors, subject to some exceptions that we'll talk about, are also not liable or can be protected by the corporation against any potential liability. So that's the benefit of incorporating. And then the other structure is really a trust, and we see it in the charity space with charitable trusts, but again, much less common. The most common and the most highly recommended would be to incorporate, as I say, as a without share capital corporation. In terms of your annual filings, there are some differences here. So both are required to file a corporate annual return, and what that looks like and where you would file it would depend on your jurisdiction of incorporation. So if you're incorporated federally, you would file with Corporations Canada, and you can do all of that online. If you are incorporated provincially, possibly, for instance, in Ontario, you would file with the Ontario Ministry. Then that's also done online. An NPO each year is required to file a T2 corporate return, and if you're involved in a corporation, that is the same filing that a for-profit corporation makes as well. But you would just sort of write nil, and you would say, I'm an NPO and I'm not subject to tax. A charity does not file a T2 corporate return. Instead, what they file is a T3010 annual charity information return. It's a much more robust tax filing. And we will talk a little bit about the T30 return later in the presentation. And then in some cases, an NPO is also required, in addition to their T2, to file a T1044 NPO return with Canada Revenue Agency. And it really depends, the requirements for that filing are bulleted below, but it essentially depends on the value of your assets and the amount of money you receive in a given year. So a lot of NPOs operate and they don't make any filings. And so if this is news to you, then hopefully you're taking note that at the very least, an NPO should be filing a T2 corporate return, and as I say, maybe subject to filing the T1044. Okay, I've lost my ability to go forward. Next. Okay. The purposes of an NPO and a charity are oftentimes very different. So a nonprofit organization can be established for any purpose other than profit. So there is tons of flexibility on the type of activities that an NPO can engage in. A charity, on the other hand, needs to be incorporated for exclusively charitable purposes. And not only do they need to contemplate charitable purposes, but they actually need to be framed in a way that CRA accepts as charitable as well. So the language is actually very, needs to be very specific when we talk about incorporating a charity. So if you're an NPO and you're considering registered charity status, likely what you're going to have to do is also look at your corporate documents and determine whether you need to maybe revise them and file an amendment to change the actual way in which your purpose is framed. The next sort of subtopic is revenue generation, and this is really where we see the biggest difference for an NPO versus a charity. So a nonprofit organization is not permitted to engage in business activities. It can engage in activities that generate revenue or income, so like membership fees, for instance, or offering certain programming like workshops at a cost. That's fine. But an NPO needs to operate or should be operating flat. That is one of the biggest rules applicable, tax compliance rules applicable to an NPO, is that they need to operate flat and they cannot engage, or they should be operating flat and they can engage in business activities. Charities, on the other hand, have much more flexibility in this regard. They can engage in business activities, provided they are what's called related business activities. And in some cases, some of their revenue generation may actually fall outside of what's considered a business activity and might actually just be a charitable activity. So there's a lot more flexibility when it comes to revenue generation for charities than for NPOs. And similar to the next point on the ability to receive grants from other registered charities, an NPO cannot receive a grant from another registered charities, which limits its ability to fundraise from private and public foundations, for instance, whereas a registered charity can receive those grants really with no even agreement in place. There's a free flow of funds permitted between registered charities. Both do have the ability to receive government grants. Both do have the ability to engage in fundraising, and both do actually have the ability to accept membership fees, although we don't often see charities with membership fees, but that is possible, and they are permitted to do that, and they are permitted to issue donation receipts for those membership fees. Which brings me exactly to my next point, which is the ability to issue donation tax receipts. A registered charity can do this. That is the biggest benefit of being a registered charity, is this ability to issue a donation tax receipt in exchange for a gift, and NPO absolutely cannot. When it comes to remuneration of directors, an NPO can actually pay their directors in their capacity as directors. A charity cannot. Now, that doesn't mean that a charity cannot make payments to directors for services rendered. They actually can. And in Ontario, the law relatively recently changed to provide more flexibility for charities to be able to make payments to directors. Initially, you had to go to court to get an order to be able to make a payment to a director for a service rendered, like for legal services or accounting services or consulting services. You had to go to court to get an order. Now in Ontario, you actually can provide those types of payments, but there's a laundry list of considerations that need to go into whether or not those payments are permitted under what's a statute, is what's called the Charities Accounting Act. So if you're considering if you're a registered charity and you're considering making a payment to a director, you do need to consult with the Charities Accounting Act and consult with some lawyers to make sure that you are able to make those payments without breaching the trust rules there. The other sort of point of difference is on the consequences for failure to follow tax compliance rules. So if you're a nonprofit organization and you fail to, and you get audited, and CRA says, look, you were not following the rules in 2017, 2018, and 2019, you engaged in business activities, you failed to file your T1044 return, and whatever else they've decided that you failed to do as an NPO, what will happen is you will be considered to not have been an NPO in those years, and you will be assessed for taxes owed on the income that the NPO generated in those years. But you will not lose your tax exempt status in any way. This is not the case for a registered charity. And this is a huge difference as well. if you fail to follow the tax compliance rules applicable to registered charities, and there are quite a few of them, which is another stark difference between the two types of organizations, then there's a variety of penalties depending on the severity of your breach. So the least, I guess, punitive penalty is an education letter. So if a charity gets audited and they're found to be, not following certain rules, maybe they're not keeping books and records quite as they should, maybe they're issuing donation tax receipts that are missing some piece of information that's required to be on there, something a little bit lighter, they might get an education letter. And all that is CRA saying, look, we've identified these places where you're not quite following the rules. Here's what you need to do to follow them. Go forth and do it. That's great. That's sort of the best case scenario. The next thing is a compliance agreement. CRA might audit the charity and say, you're not following the rules in these particular areas. We think that it's sort of serious enough that we want you to enter into an agreement with the Canada Revenue Agency where you promise to start following the rules in these particular areas. The reason a compliance agreement is important to follow is that if you get audited in a subsequent year, you've got a compliance agreement on file, and you're found to have been in breach of the rules again for something that you already promised that you would change or would start to do or what have you, then CRA can actually then assess you for a much higher or much more severe penalty. And so if you ever are in a particular situation where you get audited and CRA wants to implement a compliance agreement, seek some legal advice on that, because what we might try to do in some cases is get that down to an education letter. Because once you have that compliance agreement on file, you are really held again to this higher responsibility to make sure you follow the rules. I mean, you always should be following the rules, but there's just more penalties if you've got this compliance agreement registered on file than if you didn't. And then moving up the ladder, there can be financial penalties, there can be suspension of receiving privileges, and then the worst case scenario is a revocation of charitable status. And this is kind of why we say you should always be following the rules. A charity can exist for 20, 30, 40 years and be totally in breach of the rules and no one would ever know. But once you're audited, if that comes to light for CRA and and they decide that the severity of the breaches is enough to require revocation of charitable status, then the penalty to the charity is, well, 1, you lose your charitable status. So you can't issue donation tax receipts. 2, it's obviously very bad PR. But 3, you're really effectively shut down because you are then subject to 110% penalty, which is valued at 110% of the value of your assets. So it really means you have to forfeit everything that the charity owns. And you either need to donate it to another registered charity or you need to give it to CRA. Additionally, any director that is on the board of a registered charity that has had its revocation revoked for a serious breach or material breach, and they don't define serious or material breach, it's subject to CRA interpretation. But for a serious breach, then you are then considered to be an ineligible individual. And then you are restricted from serving on other charity boards. So there's a whole host of issues that matter for the charity and repercussions for the directors if you get your charitable status revoked. So that's kind of the thing that charities need to live in fear of a little bit when they're engaging in their activities. The other point of difference is on political activities. So both MPOs and charities can engage in what's called nonpartisan political activities, but a charity cannot engage in what is a partisan political activity. So a partisan political activity is anything where you are advocating for or against a particular political party or candidate. An NPO can do this, so you can strike an NPO for the express purpose of trying to disrupt the Liberal government or the federal government, or to try to get people to vote against a particular candidate. That's fine. A charity cannot do that. Okay, and then so moving on to sort of the pros and what I say are considerations of charitable registration. So the pros are really the increased ability to generate revenue, right? I mentioned you can get donations from other registered charities, and public and private foundations have a lot of money and they're subject to what's called the disbursement quota. They have to give that money out, a certain amount of that money out in a year. So you get more revenue that way, plus the ability to issue donation receipts is a huge revenue generating benefit. And then there's more transparency in that your T3010 filing and your financial statements actually are subject to public disclosure. They are filed online. You can search any charity that exists in Canada on CRA, and you can get access to their T3010 filing. So in that way, there's more transparency. The public, has a little bit more buy-in, more trust in the organization because they're held to this higher standard. Some of the considerations, and they're listed as causes there, but I really consider them as more considerations, is that one, there's a lengthy application process to become a registered charity. There is somewhat decreased flexibility in activities. And I say this because when you are incorporated and registered, you need to be registered for a particular charitable purpose. And the activities you engage in need to be in furtherance of that charitable purpose, regardless of whether it's a charitable activity. And I'll give you an example. So if you have an organization that is a poverty relief charity, and the activities it does in furtherance of poverty relief is it runs a soup kitchen, charitable. And it decides, it's evolved, the activities have evolved, the corporation's grown, and you want to now provide financial literacy training to, people and folks in the Black community or whatever. Even though that activity in isolation is charitable, it is not an activity that furthers the relief of poverty purpose that you said you were going to operate for. Now, that's not a problem. What you can do is you can amend your corporate documents and you can update CRA to say, look, we've grown and we've evolved and these are the types of activities we're doing, and that's fine. But if you're ever audited and your purposes don't match your activities, then you can actually be assessed a penalty. So it's just something you always have to think about. Directors always need to be aware when they're providing their oversight. Are we operating in furtherance of what is our charitable purpose? And are we engaged in activities in furtherance of that charitable purpose? And do we need to amend our documents to reflect a growth or a shift? Another sort of consideration is actually more transparency here as well, because what it also means is that you are subject to more public scrutiny, right? The ability for everyone to take a look at your financial statements, to see what kinds of donations you get in, to see how much revenue you generate. That leads to public scrutiny. To see how much you spend on administration, I actually say unfortunately leads to public scrutiny sometimes, because you do need to spend on admin to get the job done, but sometimes that can be viewed as a negative if it's deemed to be too high by the public. There is increased administration. You need to file your filings. You need to make sure that you are keeping proper books and records. You need to make sure that you are issuing donation receipts. And if you're getting a lot of donations in, then that's a lot of admin to make sure those receipts get out to the donors and are issued properly. And as I say, there's just generally additional compliance obligations. So what does the application process look like? Well, the first step would really be, you need to determine your organizational structure. So before you apply for status, so whether you're a new organization or whether you're existing NPO that wants to get charitable status, take a look at your org structure. And if you need to reorganize, then do that before you get registration, because you are going to need to file your corporate documents with Canada Revenue Agency. You are going to need to make sure, as I mentioned before, that your purposes are charitable. That you've got bylaws in place. Those need to be filed with CRA. So make sure that all of your corporate ducks are in a row before you apply for charitable registration. The next sort of step would be ensure your statement of purposes are exclusively charitable, your bylaws and corporate filings are up to date. Then this is very new. So you should register for a CRA My Business account. So CRA, as of last year, shifted, well, I think they've had it around for a long time, but really on the charities side, shifted from requiring online filing, paper filings to online filings. And they want every MPO and charity to have a CRA My Business account. So if you're part of an organization that does not have a My Business account, I very, very, very strongly encourage you to get one. It actually makes your life easier. It can be I will say, a bit of a nightmare to set up, because I think every single one of my clients has struggled. They've had to call CRA. The CRA is very good at walking you through the setup. One of the things that is sort of unfortunate about the system is a current director or officer that is listed with the Canada Revenue Agency or listed on the corporate documents needs to be the one to set up the My Business account. So I can't set it up as counsel, your accountant can't set it up as counsel, but you can authorize, once it is set up, you can authorize your service providers or others on that account to be able to make the changes for you. And some of the changes you would make would be, changes to your directors. Your tax return filings used to be have to be paper filings, and you can do that online. And importantly, you can submit your application for charitable status online. Which brings me to point 5, which is once you have your My Business account set up, you would complete and submit your application. And small plug, you would consult with Miller Thompson, of course, in filling out that application and making sure you get it right. And then in terms of timing, it's about 5 to 8 months for CRA to process your application from the date upon which you submit it. Sometimes that can be a little shorter, sometimes it can be a little longer, particularly now that the Charities Directorate has all its officers working remotely. They tend to get to the application faster, but it tends to take a bit of a longer time for them to actually review it.
Natasha, may I just ask a quick question?
Of course.
2 things you said. After revocation of a charitable status, and that the persons are restricted from serving on other charity boards. For how long? And also, is that the same for an NPO?
So it is not the same for an NPO. This is just something that is relevant for charities. And I believe it is 5 years, and it's not I will qualify that by saying it's not a full-on restriction. If you wanted to serve on a charity board and you were an ineligible individual, the charity would need to give a reason to CRA as to why you should be permitted to serve. So it just adds one layer of just sort of an admin or a thing you have to do to be able to serve. But that also means that CRA could deny it and say, no, you can't serve.
Okay. So the other question I had, you mentioned about charitable administration, that you have to keep checking that your percentages. Is there a percentage fee that charities are not allowed to go over, like after donations? How much should you be spending versus on admin? That's a big one.
There's not a certain percentage. I mean, CRA does expect that most of your expenditures will be on your charitable activities. So there isn't sort of anything set in stone, but certainly what they don't want to see is that you've got, 90% of your revenue going to admin or going to third-party fundraisers or going to fundraising events, and only 10% going to your actual charitable activities. That would be something that CRA would actually have a problem with. And then what I mean in terms of the public disclosure in that way is sometimes the public can get in its mind what's an appropriate amount, because you get charities that make claims sometimes that say 100% of our donations go to our charitable activities. Well, that can't be true because you've got admin, unless you really have no staff and it's completely volunteer, and you have no expenses, occupancy expenses, you don't have to buy a single pen or pencil, then that wouldn't be the case. But because those claims have been made a lot of the time, or because those representations have been made, sometimes the public has it in their mind that as soon as you have an admin fee, the charity is misusing or misspending their funds. They must be, because 100% is not going to their charitable activities, but that's simply not the case. So I just say that's why that public transparency piece can sometimes be, or a public can lead to public scrutiny. Although if it's properly managed by the charity, you should be able to address any kind of allegations in that regard.
Okay, so continue, please. I just wanted to get those in.
Sure. So I kind of went through some of the lengthy application process, and you've got increased obligations. So a lot of NPOs say, well, why would I become a registered charity? Can't I just work with a charitable trustee? And to that, I would say, no, you actually can't. So this concept of a charitable trustee is a concept that comes out of the States, and it's kind of migrated its way, that term has migrated its way up to Canada. The US has very, very different rules and much more flexible rules around what charities can and can't do. So this concept of operating as finding a charitable trustee means, organizations think they can approach a registered charity, or they get approached by a registered charity, and the charity will accept donations on their behalf and earmark them and flow them through to the NPO. Or the organization will lend its charitable registration number to the NPO to be able to facilitate the NPO's fundraising. That is actually 100% not allowed, and it's less of a less of a compliance consideration for the NPO, and it's much more of a large compliance breach for the registered charity. But if you're an NPO that gets approached or wants to approach an organization for this type of thing, the thing that is relevant for you is that once the funds go into the charity, they are the charity's funds. So one, they could decide not to send them to you, okay? Two, if they're ever audited and CRA wants to revoke their status, that charity status, for whatever reason, whether it's because of the improper flow of funds between the NPO and the charity or any other compliance obligation, you've lost those dollars, which means you've now probably also impinged upon your relationship with your donors, because now you don't have any money. This money that they gave to you through your charitable trustee has now been taken away, and you have no rights or claims to it. There are ways, of course, that charities can work with NPOs, but it's a much more complicated structure than simply holding funds in trust for the NPO. So I very, very, very strongly caution if you are if you are part of an NPO that is, or a charity actually, that is in one of these relationships as a charitable trustee, make sure you get some advice on making sure that the flow of funds are properly structured, because at law, technically, charitable trustees are not permitted in Canada. So what are some of the ongoing tax compliance obligations then once you get your charitable status? Well, you need to maintain proper books and records. You need to make sure you're issuing proper donation receipts. And I've got some slides that go through the checklist, and I won't go through the checklist on the call. We'll make the slides available to everybody after the presentation. You definitely need to file your T3010 annual charity information return on time. These are due 6 months from within 6 months of your financial year end. And this is a huge reason why charities get revoked, is for failure to file. CRA will sometimes issue a reminder, and will sometimes issue a reminder in advance and a reminder after that it's overdue, but you cannot rely on this reminder as a reason why you didn't file. So if you don't get it, you're still obligated to do it. So you need to keep track of that, or your accountant needs to keep track of that. You need to be wary of providing private benefits. So there's a huge rule, or a very important rule applicable to registered charities, and it's that they need to be constituted for a public purpose. They cannot be constituted to serve a corporation or certain individuals, and they certainly cannot do something that effectively relays a private benefit. They cannot use their resources to the benefit of what's called a non-qualified donee. So you have to be very careful when you're flowing funds to organizations that are not registered charities, that you're not seen to be providing a private benefit. I will put a caveat on that though, because if you're part of like an education charity that provides scholarships, that's a clear private benefit to the individual receiving the scholarship. Ancillary private benefits are fine, with what they call ancillary and incidental, but they need to be ancillary and incidental to your overall purpose, which in the example would be education. And also, I would also caveat this statement by saying, if you are providing services to a historically marginalized or underrepresented or underserved community, like the Black community, that is fine as well. So it depends, I say be wary of providing private benefit, but if you are providing a private benefit, get some consultation on it to make sure that it's permitted.
Natasha, may I just also stop you here?
Sure.
Someone is asking, when it comes to trustees, some grantors ask that an NPO partner with a charity be able to provide grants to the charity, be the lead applicant,
Right.
meaning that they get and responsible for the funds. What can NPOs do to be protected in that case?
Sure. So that would be a situation where you would enter into the proper agreement between the two of them, and you would structure the relationship. And so what it means is the grant from the government, let's say, or the funder, will flow to the charity, but then the activity needs to be framed as an activity of the charity, and that it is the MPO is acting, let's say, as the charity's agent and engaging in the initiative or activity on behalf of the charity. So that's why I say it's a little more complicated than a straight flow of funds. And then what needs to happen is the MPO, as it engages in the program or offers the program or activity, needs to then provide reporting back to the charity on activities and on finances. And the charity needs to make sure that it retains the right to stop the flow of funding if it doesn't get the proper reporting back. And then presumably that charity would then need to report back to the funder on the use of funds. So it's how you kind of structure the relationship that's important. It's more so than whether you can flow funds at all. But it's just this concept of charitable trustee where the charity is lending its charitable registration number. That's problematic. So if you've got a funder that asks for that relationship, definitely come and get legal advice on how to make sure that's structured properly.
Thank you.
No problem. And then, so the next one, make sure this actually is exactly what I was talking about, implement the proper agreements when working with intermediaries, and then make sure you exercise the requisite direction and control over your resources. So I won't go through the donation checklist. I'm just mindful of time. You know what? I think I've actually run out. I think I need to move on and hand it over to Zeineb. I was going to go through some governance considerations. The slides are there. Please take a look at them. And if anybody has any questions for me after the session, happy to take a call or to chat over email. But I just was planned on going through some governance considerations, but I think I've run shy of time. So on that, I will hand it over to Zeineb to talk to you about some employment considerations.
Thank you, Natasha. So I'm also mindful of the time. So what I will try to do is go through the slides as quickly as possible, because I know that there are a few questions and we'd like to leave some time at the end to take some questions as well. So the key resource in any organization is its people. My goal in maybe 10 to 15 minutes is to go through the key elements of people management. So I'm going to start by in the beginning. Before you start the employment relationship, I'm going to talk about some of the things that you need to consider. I'm also going to talk about key obligations that are on employers during the employment relationship, as well as, finally, some key considerations when you are ending the employment relationship. So let's start with our first slide on this section. So the first thing that I want to talk about actually is before you start the employment relationship, you have an organization and you need to hire someone to do some work, right? I find that often at this stage, some organizations, particularly smaller organizations, will decide to hire a person to work for them as a contractor rather than an employee. And there are a lot of reasons that organizations decide to go down this route. It's often more cost effective. It's often allows you more flexibility. And I think, frankly, the biggest attraction is that if you're hiring someone as a contractor, and if it's a true contractor relationship, then you are not bound by a number of legal obligations that you would be bound by if that person was an employee. The reason why I wanted to include this particular section in today's presentation is because while there are many benefits to engaging in a contractor relationship, mistakenly treating someone as a contractor can lead to significant liabilities down the road. So just because you call someone a contractor, just because the contract says that someone is a contractor, does not actually make them a contractor. And it doesn't mean that a court or an adjudicator down the road will look at that relationship and consider that person to be a contractor. You have to really consider the relationship, the nature of the relationship, and how it's going to work. If the relationship is challenged, then a court or adjudicator will often review the facts of the working relationship to determine if it's truly a contractor relationship or if it's actually an employment relationship. So if someone who is brought on to be an employee brought on to be a contractor is actually determined to be really an employee, even though you've been calling them a contractor all this time, the employer can be exposed to fines or penalties for failing to meet their obligations, but they can also be exposed to damages or awards against them. So, for example, if you are in an employment relationship, you have to comply with employment standards. The employment in Ontario, the Employment Standards Act, which sets things like minimum wage, hours of work, overtime pay. It requires you to provide severance pay and termination pay. So if you are entering a relationship and you've completely ignored all of these rules because you think, I don't have to comply because this person's a contractor, and then 5-10 years down the road, that person challenges the way that you've characterized the relationship and you've been paying them and treating them, and then the court agrees with them, then you're on the hook for potentially quite a lot of money. So I think it's a really important thing to think about before you enter the relationship. It is always problematic if it's, and in my own practice, I help employers at the outset of the relationship, but I also do a lot of defense work when relationships fall apart. So it's been my experience that recently there's been an uptick on people alleging that they have been misclassified as contractors when they should have been employees. So certainly something to think about. My advice is always to think about it before the relationship begins. There are factors that the court and adjudicators consider when they are determining whether the actual relationship is an employment one or a contractor relationship. There's a whole laundry list of considerations and factors to look at. My recommendation is to work with legal counsel at the outset of the relationship. We often develop a checklist with our clients and go through it and then give them an idea of where the risks are, and then they can make the decision having a clear understanding of whether or not they have risk, but also structuring the relationship so that they minimize those risks and put into place the protections that they have. Now, I am going to speak about the employment relationship. So assuming that you are proceeding and this person is going to be hired on as an employee, you want to make sure that you have a written employment contract in place. I am a huge proponent of written employment contracts. So I am a little bit biased. Obviously, I'm an employment lawyer, so I have, it's what I do. I draft employment contracts. But for employers, having a written employment contract is a hugely helpful thing. It helps you, first of all, have some certainty as to what the terms and conditions are. Because even if the employment contract is not written, there is still an employment contract. And so the benefit of having an employment contract is that you have the terms and conditions that govern the employment relationship clearly set out in writing, so that you're not later having to deal with terms that have been implied into the contract or out of the common law and leaving it to a judge or adjudicator to decide what the relationship, what the governing terms of the relationship are. So in terms of, can we go back to the earlier slides, Natasha? In terms of the things that you want to make sure you have for an employment contract, it needs to comply with the employment standards for the specific province that you operate out of. So if we go back to the first slide, actually, Natasha, thank you. Thank you, Natasha, for sharing the screen. I asked Natasha to share it because I knew that I would be terrible at figuring out how to do it. Complying. So the first step I think that everybody needs to be aware of is, we've got minimum employment standards in each jurisdiction in Canada. You have to make sure that you are drafting the employment contract and conducting the employment relationship in a way that complies with the minimum employment standards contract, minimum employment standards legislation. So if you have an employment contract that is that gives someone less than what they are entitled to under the employment standards legislation, then basically that term in the employment contract is not going to be enforceable. You cannot contract out of the minimum employment standards. And so it's really important to draft the contract to make sure that it gives the employee either the minimum standards or something better. The contract has to be clearly drafted. We see this all the time. If you've got a contract that is not clearly drafted, and if there are ambiguous terms, then that could also be a huge problem down the road. Courts and adjudicators often look at employer-employee relationships, and they see it as there's a bargaining, there's an imbalance in the bargaining relationship. So often the contract is drafted by the employer, and so often ambiguities are resolved in favor of the employee. So you want to make sure that you are as clear as possible in your contract, so that the terms that you put down are then found to be enforceable and interpreted in the way that you intended them to be interpreted. And the final point on this slide is that you have to have consideration. The reason why I put this in is if you want to hire someone and you give them a contract and they sign it, then they start working after the signature is on the paper, then that's fine. There's no problem. I often see situations where on the first day, the employer hands the contract over to the employee, and then they do the training and get them working in a week, and then they follow up 2 weeks down the road and ask them, have you signed the contract, and then get the contract back. And down the road, if the relationship ever breaks down, you might have a situation where that employee says, well, there was no proper consideration because I had already started working. And then you gave me a contract which took away some of my rights, and you didn't give me anything new, any new consideration. So you want to make sure that somebody signs the contract before you get them started as an employee. So if we could now move on to the next slide, I will touch on some key employment terms that you want to make sure you cover in your employment contract. So I won't go through all of them because some of them are just listed there so that you have the benefit of thinking about them when you're drafting your contract. But I want to touch on a few of them. So the first one that I'm going to talk about is whether the contract is going to be fixed term or indefinite term. So if you're hiring somebody because you are bringing them on and you've got a certain budget and a project, right? And that might be the case often. You've got a mandate, and it's not for an infinite amount of time. So that person is being hired to work specifically for a project that is for 6 months. Then you want to clearly identify that the employment contract is a fixed term employment contract. And it is going to be important that you set out the start date and the end date of the contract, but also that the contract can be terminated in accordance with an early termination provision. That is really important because there are cases where people are terminated and the employer thinks, well, even though there's 6 more months in the contract, I can terminate them and just give them what they're entitled to under the SA. The courts have looked at those situations and said, no, because you didn't have an early termination provision in your contract, you owe them the balance of the contract. So then you're on the hook for the rest of the term, even though you thought you could get away with just giving them what they're entitled to under the SA. So it's going to be important to think about an early exit strategy if you're in the unfortunate situation of needing it. I want to now touch on, so I would advise that you put together in the contract a list of duties, description of the position, and the reporting relationship. And with respect to the duties, I always advise that you should keep some flexibility for yourself, because sometimes positions evolve a little bit, and you want to always be able to move with the times or move as things change along, right? You don't want to be in a position where you ask someone to do something and all of a sudden they're saying, well, that's a constructive dismissal. You're changing a fundamental term of my employment by giving me these duties, which are not part of my job. So I see a lot of those cases. So make sure you build in some flexibility in the employment contract when you're setting out the duties and responsibilities, and it helps you, overcome some of those challenges if you are ever in a place where someone makes those kind of allegations.
Zeineb, could I interrupt and ask you 2 things?
Of course.
Something like a clause that says sundry duties as assigned. Is that a good idea to put in so that gets you away from, if you needed to add other things?
Yeah, that's kind of what I usually draft is I set out a list and I would say, and as may be assigned from time to time, consistent with these duties or something like that. Obviously, I still encourage you to think about what you're assigning to the person. I mean, if you're hiring someone in a job, you know, as an accountant, for example, and then their job is, you know, clearly to deal with this specific thing, and then all of a sudden you're like, well, the receptionist is not here, so now you have to cover reception for the next 6 weeks. That's a problem, right? The fact that your contract says you have flexibility is probably not going to get you out of the fact that you are changing someone's job entirely.
Okay, someone on the call asked, are the expectations the same for smaller businesses with, say, 1 or 2 staff being paid minimum wages?
So that's a great question. So the way that so if we're talking about, for example, the Employment Standards Act, which sets out the minimum standards that you have to comply with, most of the minimum standards are general, applying to the employment relationship, but there are exceptions for certain things. And it's not necessarily tied to the size of the organization. For example, severance pay is one where it would apply for employees who have 5 years and more, but only for employers who have a $2.5 million payroll or more, right? So that's an example of a standard minimum entitlement that is not going to apply to all employers. There are other exemptions, for example, overtime. Not everybody's entitled to overtime. I'm not entitled to overtime as a lawyer. Most professionals are not entitled to overtime. People in true managerial positions are not entitled to overtime. But yes, there are exemptions. I would say for you know, the one that makes the difference between a small organization and a big organization for employment standards is really severance. The rest of them, I would say, generally apply unless there are specific exemptions that would apply. So it's important to make sure that you understand where you fall in as an employer and what your obligations are.
I have one more because I want to just make sure we don't miss anybody. Nika says, as a non-for-profit, can you hire staff as a temporary status and allow the person to file their own taxes based on agreed payment rate and renew that temporary employment annually? It's a little bit of a confusing question, but yeah, do you get it?
So it sounds to me like the question is really about hiring someone on as a contractor. I think that's the idea, is you're hiring them on as a contractor, so they're responsible for sort of paying their own taxes. You're not withholding taxes. And I would say, just going back to the initial consideration, it's going to really, if for that arrangement to work, that person needs to be truly a contractor. So you're going to have to think about things such as the factors that the courts have set out, you know, the level of control that you have over them, who owns the tools and equipment, are you giving them office space, you know, is there a financial risk or opportunity for profit and loss, how integrated are they as part of the organization, are they providing services exclusively for you, and so on. I hope that's addressed the question. I think it's in a contractor versus employee question.
Yes, it sounds like. Okay, thank you. Keep going, because I know we have about 8 minutes left and you have lots to go. This is so interesting.
Okay, all right. So what I'm going to do is I'm going to just focus on termination. So I'll talk about the termination provisions, and then because that is often like my eye. If someone asks me to review a contract, my eye always goes first to the termination provision, because that's the bulk of my defense work is wrongful dismissal allegations. So the termination provision is a very important thing to have in an employment contract. If you're going to have an employment contract in writing, then I highly recommend that you think about what that person would be getting if you were ever in a situation where you're terminating their employment. And so there's been recently a lot of case law on whether termination provisions are enforceable and not, or not. And most of that case law looks at the termination provision with the lens of whether or not the employer is trying to, or either trying to or has drafted the termination provision in a way that gives that person less than what they would get under the minimum employment standards legislation. So employment standards legislation has, in Ontario, it sets out specific notice obligations for the employer if you're terminating the employment relationship on a without cause basis. And so it will differ depending on that person's length of service, but it generally caps out at 8 weeks. And then specific severance obligation for severance paying employers, which, as I mentioned earlier, are those employers who have $2.5 million in payroll or more. And severance is actually potentially a bigger liability. So it is going to be really, really important to draft the termination provision so that it clearly does not provide for less than the notice and severance obligations under the Employment Standards Act. And it provides for also things such as, if you are under the Employment Standards Act, if you're giving someone notice, you also have to continue their benefits. So the termination provision can't even ignore benefits, or it has to look like it covers benefits as well. So there's, it's a really key thing, and it's very technical because the courts have been reading these in a really strict way. And so there have been lots of termination provisions, I would say, in the last 10 years that on a quick reading, it looks like it's perfectly fine, but they found a way to invalidate them. And so the problem with that is that if that clause is found to be unenforceable, then you end up with no termination provision in your contract, which means the court will look to this concept of reasonable notice at common law. And so reasonable notice at common law means that a court is going to consider certain factors in the relationship. So they're going to look at the person's age, the person's length of service, and the type of position they have. And they're going to come up with a number of months of what this particular situation, what that particular employee is entitled to in terms of notice of termination. So, so if you've got somebody who is in a senior level position, who's had, who's been working for you for 18 years, and the court might give them 1 month per year of service. They might give them 18 months. So that's significant, right? And you want to make sure that if you want to limit your liability, you draft the termination provision so that it is enforceable, it doesn't get struck out, and you're not leaving sort of the termination notice obligations to be determined by a court based on those factors. Now,
so I do know that we do have 4 minutes. So I do want to get some of the questions in the chat.
Okay,
answered.
sure.
And two of them are for Natasha. So Natasha, it says, for a scholarship-based nonprofit that has been incorporated for 25 years without charitable status, would you recommend updating the letter's patent before applying for charitable status?
Not necessarily. So actually what I do recommend in that case is you can apply for charitable status with a proposed set of purposes. And the reason sometimes we do that is because of a timing consideration. So if you change your purposes and then you apply for charitable status, and then CRA determines that they want you to change your purposes to better suit your description of activities, then you're going to need to go back to you will have waited for that 5 to 8 months. Then you're going to need to go back to your board and members. And I don't know how large the membership is, but if it's large, that can be an onerous task to then get the articles or your supplementary letters patent reapproved by your board and members. And then you would have to update CRA, and then they will give you your status. So it can delay things. Now, if it's a very clear charitable purpose, like if you come to me or to another lawyer and we can very clearly delineate and describe a charitable purpose, and there's no concern that CRA would be likely to amend it, then do it in advance. But that's kind of it's a bit of a consideration, but all that to say you can actually apply with a proposed set of purposes, and you undertake to CRA to change your purposes once you get registration.
And thank you. And the second question is, what's the difference if you're to start a youth-led NPO versus a regular NPO? Is there any difference in process?
No, as long as, well, okay, I shouldn't just say no. As long as the individuals are over 18, they can serve on the board. So if by youth led, there's some involvement in kids or youth under the age of 18, they can serve as sort of a youth advisory committee, or they could serve in some other capacity as volunteers or program creators or coordinators, but they couldn't be on the board. So you do have to be at least 18 years old to be on the board of directors of a corporation, just generally.
Okay.
That would be the only consideration.
Everybody's asking, how do they get a hold of either of you? Because we have 1 minute left and it's obvious that people need advice. So can you put in the chat your contact information?
Sure, we can definitely do that. The one thing I'll mention is if we circulate these slides, the first few slides contain all of our details as well.
Oh.
But if we can also plug that into the chat too.
Right. Perfect. So BBPA will make sure, and I'm not sure how that gets done, but I'll leave that to the folks at BBPA to decide. Everybody who gave an email, they'll send the slides to you all. I think that would be the most simple way to do that. And last words, because we've got, we actually do not have any time, but could you just say final words, Zeineb and Natasha? And then I will let people know who will be speaking next week.
Sure. I think it's just a general thank you for attending, and we hope that it's been informative. I know it was a lot to pack into an hour, so apologies. I think this is my fault. We've gone over time, but please do contact either of us, email or phone, and we'd be happy to have a chat, chatting through some of your issues.
Zeineb?
Yeah, I echo Natasha's comments. Thank you, everybody, for joining us. Yeah, if there are any questions, please do reach out.
Most informative. And I do want to say it is so impressive to see such brilliant young people doing the work that you're doing. It makes me feel awesome. It really does. It really does. Coming up next week on October the 14th, welcoming Susan Henry, the manager of community investments, Alterna Credit Unions, and she'll be talking about how to do savings for small business. So folks, once again, thank you for being here, and thank you very much, Natasha and Zeineb, for a very detailed and constructive presentation. Thank you all for being on the call, and BBPA will be posting these calls soon, so you can always go back to hear the wise words of wisdom. Thank you all, and see you all next time.
Thank you. Bye.
Bye-bye.